In 1990, when the Americans with Disabilities Act was enacted into law, Internet commerce remained far into the future. Today, with billions of dollars of commerce transacting on the Internet every year, companies are being hit with lawsuits to make their websites accessible to persons with disabilities under the ADA. One such lawsuit was filed against the large national tax preparation company, H&R Block. And there are lessons for you in this lawsuit as real estate professionals, since your websites are increasingly integral to the home buying and selling experience for consumers. The lawsuit contended H&R Block's website, mobile applications, and tax preparation tools were insufficiently accessible under Title III of the ADA, which is the title requiring accessibility of places of public accommodation. We tend to think of places of public accommodation as physical places like storefronts, but the U.S. Department of Justice, which is the principal enforcer of the ADA and which joined the lawsuit against H&R Block, considers a website on which commerce is conducted to be a place of public accommodation as well.
When we think of access to places of public accommodation, traditionally we think of physical access to brick and mortar buildings primarily. We think of things like curb cuts and accessible routes into buildings and accessible bathrooms. But the ADA really is much, much broader than that.
Tom Curie is an attorney in Washington, D.C., who has been watching the website accessibility issue closely. He says the Department of Justice, since 2010, has had plans to publish a rule that would provide much-needed clarity to businesses, organizations, and to the courts on website accessibility. That rule has not yet been published. But in the meantime, the department points to industry guidelines called the Web Content Accessibility Guidelines that you can follow to help ensure your online presence reflects today's best practices in accessibility.
Well, there are steps which realtors can take to make their websites accessible today. The Department of Justice, when it issued its advance notice of proposed rulemaking back in 2010, identified 5 barriers to website accessibility. And these 5 barriers are these: websites that don't allow for a change in font size, or websites that don't allow for a change in the background of the screen of the website itself. This was necessary to allow people who have low vision to read the website. Next would be websites that rely heavily upon images without captions. People who are blind rely upon readers to translate the written word on these websites into speech. And the functioning of these readers and other technology that they rely upon is frustrated by images that don't have captions to them. Another barrier, and a similar barrier, would be websites that rely heavily upon video, audio-video, without captions also. And this makes it difficult for people who are deaf to get the content of those videos. Another barrier identified by the Department of Justice is websites that don't allow for an extension of time in which you have to act within a certain time period, but don't allow for you to get an extension of that time to respond. A person who is blind may require additional time to read what is on the website. And a final barrier identified by the DOJ is a device called CAPTCHA, C-A-P-T-C-H-A, which is an acronym. And this is a software that allows the website to determine whether or not they are being used by another computer or by a human being. And this would be a test, for example, that would use distorted letters, a combination of distorted letters and words, and you're asked to retype those letters and words into a box. And this would obviously be very difficult for a person who has low vision.
To be clear, the issue of website accessibility is not a settled one. Courts around the country are coming to different conclusions in the lawsuits that they're hearing. And while the upcoming rule of the Department of Justice, when it's published, will provide much needed clarity, there will remain questions to be answered.
The Department of Justice has taken the position that the ADA does require that websites of public accommodations be accessible. And both the Department of Justice as well as advocacy organizations and individuals are active in filing lawsuits in this area right now. There is a period of uncertainty. The government is taking steps, but regulations are still on the horizon. When regulations do become final, it would be wise to sit down and look at your website to make sure it does comply with those regulations. So stay tuned. In the interval, there are steps, which we've just talked about, which realtors can take to make their websites accessible.